Umur saya 35 tahun. Pekerjaan saya sehari-hari perkebunan kelapa sawit. Yaitu
Saya yakin Indonesia akan menjadi jantung kepemimpinan dunia suatu saat nanti. Indonesia dengan posisi strategisnya memiliki peluang untuk mengambil peran utama dalam kepemimpinan dunia. Oleh karena itu, dibutuhkan sumber daya manusia yang berjiwa kemanusiaan yang tinggi serta pola pikir dan pengetahuan strategis untuk mengambil peran tersebut. Sebagai perguruan tinggi terbaik di Indonesia, Universitas Indonesia menghadirkan
Graduate School of Sustainable Development.
Memadukan 3 pilar yakni ekonomi yang inklusif, keadilan sosial, dan kelestarian lingkungan hidup. Sekolah Pascasarjana Pembangunan Berkelanjutan Universitas Indonesia hadir bukan hanya sebagai penyelenggara pendidikan tinggi multidisiplin, melainkan juga berkomitmen untuk mencetak lulusan-lulusan yang mampu berkontribusi nyata melalui pemikiran kritis dan keilmuan yang strategis dalam rangka menghadapi persoalan bangsa yang multidimensional dan kompleksitas tantangan global secara lebih komprehensif. Demi mewarisi bumi yang lebih sehat, masyarakat yang lebih adil, dan ekonomi yang berdaya tahan bagi generasi yang akan datang, sehingga terbentuklah pemikir, peneliti, dan pemimpin transformasional yang integratif, adaptif, dan solutif untuk mampu menciptakan kebijakan berbasis sains yang relevan sekaligus berpihak kepada masyarakat.
Ladies and gentlemen, as we are about to begin, please be seated. We would like to seek your cooperation completing this agenda. Kindly switch your mobile phones to silent mode. And for all participants on the Zoom, please use the virtual background that has been distributed. Thank you. The Honorable Vice Director for Academics and Student Affairs, Dr. Fuad Gani SSMA, Vice Director for Finance, Resources and Cooperation, Insinyur Mauren Pomsar Lumbantoruan MM, Profesor Yuka Kaneko, Land Law Corporate Sustainability, Profesor Kozo Kagawa, Labor Law, Profesor Makoto Kurita, Competition Law, ASEAN Competition Policy, Profesor Terukazu Suruga, Development Economics, Ms. Novi Nurfiani from Bappenas, Dr. Andreas Pramudianto, SHMSI, Environmental Law and Dispute Resolution in Indonesia, Mrs. Mia Siskawati Eshut, MA, PhD, Gender Perspective in Labor Conflict Resolution, Dr. Hayati Sari Hasibuan, STMT, Manager Research and Community Service, Mrs. Iren Sondang Fitri Nitya, SSI, MSI, PhD, Executive Assistant to Director for Performance Planning. And to all respected professors, lecturers, and participants whom I cannot mention one by one, good morning and welcome to International Seminar Development of Laws and Dispute Resolution in Asia in Search of an Alternative for Sustainable Development, Thursday, 22nd of August 2026 in UI Campus Salemba. My name is Esther Renata Patricia, and I am deeply honored to stand before you as your master of ceremony in this remarkable agenda. On this occasion, allow me to present today's agenda as follows. The seminar will begin with the opening remarks. This will be followed by introduction and seminar overview, followed by presentation and discussion led by moderator, and then closing remarks and photo session. Before starting those agenda, I invite you to stand up and to sing Indonesian National Anthem and Hymne UI. Please be seated. Distinguished dignitaries, ladies and gentlemen, the next agenda is opening remarks delivered by Vice Director for Academics and Student Affairs to Dr. Fuad Gani, SSMA. The floor is yours.
It is a great pleasure and honor for me to give opening remarks in this seminar on development of law and dispute resolution in Asia in search of alternative for sustainable development. This theme or its topic is deeply relevant to the challenges we are facing today. Both as a scholar and as a member of societies undergoing rapid transformation in the digital and AI era. Right now, in Asia, development is accelerating at an impressive pace. However, alongside this progress, disputes related to land, natural resources, and environment, good governance, and conflicting economic interests become more complex and more frequent. This seminar reflects critically on whether our legal and dispute resolution system are evolving fast enough to support development that is truly sustainable, just, culturally correct, and socially legitimate. Asia today embodies a profound development paradox. That is a very important thing that we try to underscore regarding about this paradox. We know this region is a global engine of economic growth, technological innovation, and infrastructure expansion. At the same time, admittedly, Asia also faces serious inequality, environmental degradation, climate vulnerability, cultural disruption, and social dispute. Many of these disputes do not arise because development cannot afford to occur, but because, in fact, development proceeds without sufficient balance. In ethical thought, the balance should be captured by the principle that harmony and proportionality should guide human action. When development disrupts the expected balance, conflict becomes unavoidable and inevitable. Environmental dispute, natural resources competition, and serious security resistance often escalate not merely due to the lack of regulation, but due to weak system and implementation for dealing with competing interests fairly, transparently, and compassionately. This fact challenges us to revisit and rethink the role of law, not only as an instrument of control, but as a means of restoring balance and justice within society. In this context, we are witnessing what we describe as a dispute resolution thinking across Asia. That is a gradual, meaningful shift toward mediation, arbitration, and restorative approaches, toward hybrid and community-based practices, toward adaptive and context-sensitive solutions. This evolution worked firmly with ethical and cultural tradition in Asia, peaceful settlement and reconciliation, a preferred track in resolving dispute. The idea is not to erase disagreement, differences, but to manage it in a way that honor dignity, maintain social cohesion, and everlasting relationship. Disputes in this sense are signal that governance system must respond more accordingly, wisely, and humanly. So, why the Graduate School of Sustainable Development (UI) that also offers such kind of a seminar? It is for the reason that the Graduate School of Sustainable Development at Universitas Indonesia is an appropriate venue for this today seminar. Sustainability challenges like environmental conflict and development-related dispute cannot be comprehended through a single disciplinary approach. They are all, of course, not only ecological or technical problems, they are also legal, political, cultural, and strategic in nature. Our graduate school exists to bridge this important domain by integrating environmental science, governance, law, public policy, and strategic studies within one academic circle. We see sustainability is approached not merely as an environmental objective, but also a governance responsibility. We all know together humans are entrusted with managing natural resources, institution, and power responsibly, not exploitively. By hosting this pivotal seminar, the graduate school prompts its serious commitment to producing quality knowledge that is ethically strong, ethically grounded, culturally acceptable, relevant, and applicable, as well as policy relevant, in which scholars and university students not only to analyze conflict arising from the past and the current development, but to offer legal and institutional alternative, making sustainable development both achievable and impactful. The phrase "in search for alternative" is a strong core of this seminar. It hints that while global legal norm and international framework remain important, they are not always sufficient. Asia has to also see its own ethical and cultural background, its legal pluralism, strong indigenous knowledge, community practices, and more values and tradition. From local environmental mediation to regional arbitration process, and from consistent customary land governance to climate-related dispute resolution, Asia is undoubtedly a living laboratory of legal inspiration and innovation. This effort shines a broader moral principle shared across various traditions that justice, or in Indonesia language is called adil, is a contextual which must be realized through systems and processes that are fair, inclusive, and attentive to social practices and realities. Ladies and gentlemen, sustainable development, we agree, depends not only on science, technology, or agile investment and high commitment, but on our seriousness and collective capacity to manage conflict wisely, fairly, and with moral values and responsibility. We believe law is not served not only to serve sustainability accordingly. Law should regulate acceptive behavior, establish trust, enforce rule strongly, apply justice, afford to resolve issues, and manage balance in the society. We hope today's seminar will inspire and stimulate thoughtful dialogue across discipline, inspire ethical application and reflection, and prompt innovative thinking, especially among academic circles who will play a strategic role in the future of sustainability governance in Asia. So with this, I'm pleased to officially open this seminar. So a very thank you for especially our guests that are already here early in the middle of the happy rain. We had some trouble regarding about the traffic condition on the street, and we are very so we can have a kinds of discussion regarding about this very important topic of seminar. So again, welcome on the behalf of our management. We are very happy to have you. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Fuad Gani, for your delightful speech. Ladies and gentlemen, for the next agenda, we are honored to invite Mrs. Iren Sondang Fitri Nitya, SSI, MSc PhD, to start the discussion.
Okay. Very good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. So I'm such an honor for me to standing here. I will become a moderator of this discussion. We will have 5 speakers, very prominent speakers that will talk about issue that related with the development of laws and dispute resolution in Asia. But before we go through with the topics from each speaker, I think it's nice to know about what is the objectives or aims of this event, about this seminar. So I'm inviting Professor Mizuno to talk about the introduction and also give like a glimpse about this event, please.
Thank you very much. I would like to introduce our seminar. We are so glad to have today's seminar on the development of law and dispute resolution in Asia. Actually, in Indonesia, there are so many disputes. Can you show my PowerPoint? Not that. Introduction. Yeah. For the agrarian dispute, a study count 2,612 dispute from 2013 to 2011, 2018, and also environmental dispute was counted 321 by Farini. Yeah, no, not that. Introduction. Sorry. Yeah. In the environmental dispute, in the environmental sector, there was 301 civil environmental dispute cases. And also, at the labor dispute, labor dispute counted to 10,297 dispute in 2024. So this number shows that so many disputes in Indonesia. Of course, we find many disputes sengketa in Indonesia, everywhere actually. When once there is a development program in Indonesia, we see the agrarian dispute, sengketa lahan. Yeah, so that is only one example. So that dispute has many negative impact, of course, land grabbing or the environmental degradation, erosion, and air pollution, and also labor, also union busting, and so on. So dispute has many negative impact, of course. So the dispute settlement is important agenda for us. On the dispute settlement, alternative dispute resolution is one important approach. That utilize arbitration, mediation, and other mechanisms is increasingly recognized globally. The ADRs save time and cost and serve as an alternative method for people familiar with the judicial system. Now, Indonesia has implemented this ADR with Act number 13, 1999 on arbitration and alternative dispute resolution, especially Article 9. ADR operate within a legal framework and use mediator or arbitrator recognized by the government or the court. ADR practice is found in agrarian conflict, where National Agrarian Agency play a mediator. And also, environmental dispute resolution is regulated under Act number 32 of 2009 on environment protection and management. Articles 84 to 86, especially 86, permits the establishment of a neutral, independent body by community or government that can offer several services for settlement of environmental dispute. Labor disputes are governed by Act number 2, 2004 on industrial relation dispute settlement, where article dispute stipulate the mediation, conciliation, and arbitration before proceeding to the court. On the other hand, Indonesia has a tradition of dispute settlement called Musyawarah Mufakat. That is quite old system that find everywhere in Indonesia. It is not a formal legal practice, but a normative decision-making mechanism. Decisions are made through consultation and social acceptance initiated by community leader, for example. Now, and that Musyawarah Mufakat becomes a philosophy of Indonesian people. The Pancasila is national principle for the people. Fourth of Pancasila, five principles. Among the five principles, fourth is the Musyawarah. And that Musyawarah enters the Constitution of 1945. So that is really important in Indonesian society. And regulation, for example, labor dispute regulation adopted that idea of Musyawarah. Musyawarah is mandatory for labor dispute settlement between two parties, labor and management. And arbitration and alternative dispute resolution Act 1999, or Environmental Protection and Management Act 1932 of 2009 also adopt that idea of Musyawarah. And of course, Indonesia has a judicial dispute resolution system for agrarian issue, Undang-Undang Pokok Agraria, Basic Agrarian Law 1960, stipulate the rule, and violation can be punished, and that case could be brought to general court and administrative court. Environmental conflicts are regulated by Act 32 of 2009, and the labor dispute Act number 2, 2004 stipulate the law of Industrial Relation Code, PPHI, and Act 13 of 2003 on manpower. That is revised by the Act 22 of 2020, employment creation, Undang-Undang Cipta Kerja, or omnibus law. But part of labor were ruled unconstitutional by Constitutional Court. So now the process is revising the Undang-Undang Ketenagakerjaan, Act of Manpower. But anyway, Indonesia has this three systems: ADR, ADR, and musyawarah mufakat, and dispute. But also there are three systems, but so many disputes. Yeah, so question arises why so many disputes. Of course, many discussion on agrarian issue overlapping the land right, land owned by local people, but that is the state land. So overlapping the land right. The labor union busting is not easily controlled. Labor inspection is not strong in that field. For example, so because there are many issues, so many discussions, there are many ideas to improve the situation. For example, the legal recognition of customary land right, that land with that law, or FPIC, free, prior, and informed concept. Once that principle is applied, hopefully the conflict can decrease. Or environmental conflict. Or environmental conflict strengthens the environmental liability. Or the environmental law 2009 can cover more issues such as environmental service by the forestry and so on, and for labor dispute, protection of trade union right and so on, and due diligence by UN or OECD can hopefully supply the new idea or new methodology to curb the dispute, or show to supply the way of dispute settlement. Indonesia have applied the idea of due diligence with presidential declaration of number 90 of 2023 and other regulation. So the issue is how can this dispute be solved with justice? Now that is main issue that we should address our discussion. So for that purpose, we have today's seminar. So for that purpose, we have seminar in collaboration with Kobe University Center for Social System Innovation. We invite the Professor Kozo Koyama, who are specializing labor law, and Professor Yuka Kaneko, who are specializing land law. So from our side, Pa Andreas will provide the discussion of environmental law. Even Mia show the discussion of labor law, and me show the discussion of land law. So this seminar seeks to assess current practice and explore alternative dispute resolution pathways that better support sustainable development. Thank you, David. And this is my introduction for this today's seminar. Thank you very much.
So thank you, Prof. Mizuno, for the introduction. So I think we already know about the purpose of this seminar. So the one big question is about how can these disputes be resolved with justice. So through the five speakers that will talk or discuss about any disputes related with land or environment or labor, we will know about the dynamics and also this kind of phenomenon that happen not only in Indonesia but also in Asia in general. So as Prof. Mizuno mentioned about the speakers, we are very delightful to have a prominent expert from the Kobe University Center for Social System Innovation. I introduce one more time for Professor Yuka Kaneko and Professor Kozo Kagawa. And from Universitas Indonesia Graduate School of Sustainable Development, we also have Dr. Andreas Pramudianto and Mia Siskawati, PhD. So in the beginning, for the first speaker, I will invite Dr. Andreas Pramudianto that talk about the topic about environmental law and dispute resolution in Indonesia. He is a lecturer in environmental science, a prominent researcher regarding politics and environment law. His publication about the dynamic diplomacy of global climate change and ASEAN towards 2025. He also produced several books about the international environmental law, environment diplomacy, theory and facts. So please, Dr. Andreas, your time is 20 minutes. And after that, I will, if 5 minutes you will finish, I will tell you. Okay, I will remind you. Okay, so just come here.
Good morning, ladies and gentlemen. This is the problem, my problem. My problem is speak English well because I'm not always speak English. Yeah, this is the problem. But I will try to speak. Today, I want to talk about the environmental law and environmental dispute resolution. Yeah. Next, this is problem in, Prof. Mizuno said that many problem case of law in Indonesia, especially in environmental law. The development of a law in ASEAN, especially in there are development, in regional integration, such as in ASEAN, development of legal, development of policy and other else. It's, for example, an ASEAN have dispute resolution to finish the many case. ASEAN, such as ASEAN, so mass adaptation of globalization. There are many agree about the international convention, including the ASEAN Regional Convention as established. But the problem in ASEAN, there is regulation harmonization. It is not easy. But ASEAN always try to harmonization of regional law. Human rights protection and cross-border enforcement and global norms. It's development until today, ASEAN law. Next, how about the environmental law in Indonesia? Environmental law in Indonesia developed the first time in law of 4 in 1982 is the remark to law in Indonesia. Yeah. But the dispute resolution still predominantly through the court. Yeah, it's very important. The first court is the forest negotiation. Yeah. The other else, law number 32 in 2009. Yeah. This is the start about the expanded dispute resolution mechanism. Yeah. Especially in alternative dispute resolution. After that, this is the recognition other mechanism such as class action and legal standing for environmental organization. Law number post-job creation law, ya. Undang-undang Cipta Kerja, ya. Strengthen mediation and arbitration mechanism, and there are Directorate of Environmental Dispute Resolution in Ministry of Environment. Next. This is a definition of environmental dispute resolution. I think it's you know that about this. Next. This is the history of regulation of environmental dispute in Indonesia. Law 23. It's I think this is the environmental dispute resolution. I mean that alternative dispute resolution. Yeah, alternative dispute resolution. Yeah, this is the first in 1997. Yeah, Article 30. In 1999, law number 30 in 1999. It is the first arbitration system in Indonesia used with the law. After that, there is a government regulation 54/2000. This is the very important because the system in the law just only talk general, especially in alternative dispute resolution. But the law need to operational system. So there is a government regulation is the operational system, especially in dispute resolution. Especially alternative dispute resolution. Yeah, but in court and out of court. Yeah. After that, there is the 2002. There are Supreme Court Circular Letter 1/2002. This is the empowerment of the peace in court institution. Next. Yeah, next. After that in 2000, next. After that in 2003, there is regulation of Supreme Court in Perma, peraturan Mahkamah Agung. Yeah. Another else, there are Supreme Court in Perma 2008 and Law number 32 2009 and regulating of about the to operational need Minister of Environmental Regulation publish about the guideline to resolving of environmental dispute. This is the regulation from environmental minister, but now it's talk or needs to change process to change this regulation. Until now, this we wait this regulation when the publish again the new regulation, because there are many new law, such as the criminal code procedure. It needs to compare about this. Next. There are many regulation others. I think Perpu number 2 is the new regulation to environmental dispute resolution. Yeah. Next. This is the other regulation in 20. This is the new system 2025. There are principle of restorative justice. This is the focus from retaliation to restoration and peace to reach an agreement. Yeah. In the court, there is a system, criminal procedure, but the criminal code, the new criminal code, open the restorative justice. Yeah. Okay. Next. The principle of dispute resolution, accessibility principle, independent principle, fairness principle, and efficiency. I think this is the general principle. Yeah. Lanjut. Next. Nah, in Indonesia, there is 2 procedur principle of dispute resolution: litigation and non-litigation. Litigation, there is many system, district court, high court, Supreme Court, and constitutional court. But non-litigation or alternative dispute resolution, there is negotiation, mediation, arbitration, consultation, conciliation, and expert assessment. Next. Okay. How about case in the court? There are many cases in the court. Yeah. Tanjung Uban case about the smuggling and pollution hazardous waste. Sidoarjo. This is the first case on environment in Indonesia. Pollution from tofu factories and pig farms in Sidoarjo. The owner decision court has free. Yeah. Not the punish, yeah. But after the Supreme Court, yeah, there is punish in 3 months imprisonment, yeah, and fine about 1 billion rupiah. Next, this is the new case or environmental case recently, yeah. Sungai Cikijing, yeah, PLTU Cirebon case. PLTU Cirebon case about the climate change case, yeah. In administrative about the permit, yeah. Case Maning Sangihe, Samarinda movement. It's about the some people to need the climate change good situation. Yeah, this is about the especially about the mining. Yeah. But the mining use system is not good to make climate change good. Yeah, Samarinda movement. In Indonesia, forest fire, many forest fire. Yeah. In some lawsuit about this forest fire Bumi Mekar Hijau case, yeah. It is the one. There are many case others in the court, yeah, in the court. But in the system of court in Indonesia, next, in Article 130, there are HIR, yeah, and RBGS. Yeah. This is the reglement, older in colonial reglement, which require a settlement and trial can process mediation part and litigation. This is the fundamental to understand about the system of law until now. Yeah. Next. So this is alternative dispute resolution, non-litigation process. Yeah. There is what's the negotiation, the party negotiation directly without a third party to reach a fair agreement. Just only one and one. Yeah. There is, for example, in the electricity infrastructure project case, yeah, the negotiation process in use of alternative dispute resolution focus to finding a solution to effective, adaptive the process of AMDAL or environmental impact assessment. because this is about the problem of Walhi and companies. Next. Conciliation. What's the conciliation? This is the similar to mediation. Yeah. Minister of Environmental with the case about PTSSS, the company of textile, issue about the permit conflict, yeah, in Kalimantan, yeah, in the mining company. Next. Expert determination. Expert determination in many forest and land fire case use this, yeah, because they need to liability and many about the evidence. Yeah. It is not easy to get evidence to.
General Union also about 6 or 8% of Japanese labor unions. So 4 types unions can be seen in Asian countries also. But there is no statistics how rates of the 4 type unions are divided in each countries. So ILO statistics, there is no ILO statistics on this 4 types ratio. So I think Indonesia has also 4 types unions. And I think the enterprise unions have dominated the Indonesian labor unions. Or not? I'm not confident in this conclusion. So, in general, labor unions have 2 roles. One is the cooperative side with enterprise or employers, and also conflictual side. In this side, division of gains or profits of the enterprise or companies. Typically, wages is a conflicting point between an employer and employee. So 2 sides can be mentioned. And labor union movements are fragmented into so many kinds of labor unions movement. Singapore is an exceptional case. Totally, labor unions are divided into 2 groups: amicable strategies group and the conflicting strategy or militant strategy group. So decided. So next, please. Here. So in Asian countries, compulsory registration systems of labor unions are adopted. So this registration system of labor unions started from the England. This England system are inherited to Indian and Singapore and Malaysian and the other countries. And then this registration system of labor unions are broadened to Asian countries. So, under the compulsory registration systems, labor unions shall be illegal if the registration is refused or cancelled. So, under this system, strength of government to control labor unions becomes stronger and stronger in each country, Asian countries. So, next point is collective bargaining. Collective bargaining scope, in general, enterprise level bargaining, and also another type, industrial level type, and craft level type of collective bargaining. And so, I think in Indonesia, enterprise level or industrial level collective bargaining are held. So, to start the collective bargaining, employer must recognize the labor unions as parties of collective bargaining. So, this is named as union recognition. So, employers sometimes do not recognize labor unions, violating the basic rights of workers. In Japan and the Philippines, unfair labor practice systems is introduced under the jurisdiction of Labor Relations Commission. And so, to promote the collective bargaining, I must divide the cases in two cases. Only one labor unions in the enterprise or industry, or multiple labor unions existed at the enterprise level or industrial level. And so, only one labor union exists in the enterprise level. This is so simple. So, employer recognize only one labor union as a target. But in case of multiple labor unions, it is so difficult task for the employer which labor unions can be chosen to the target of the labor union collective bargaining. So, in this multiple labor unions, sole bargaining representative per bargaining unit systems are introduced in some Asian countries, typically in the Philippines. This bargaining unit system started from the America, USA. Philippines labor law are inherited from the Americans. So, Philippines introduced the unfair labor practice systems. And so, in this system, bargaining unit system was adopted. So, in this case, in secret ballot was chosen to appoint the labor union to choose the parties of the other parties of the collective bargaining. And another system is a certification of membership system. In this system, membership list must be kept by each labor unions. But this list is real or not? This is so questionable to decide the new membership list is real or not. For example, union members must pay the union dues regularly, but sometimes they do not union dues. But the other members, that list in the list, union list, union members list, is not union member list. In the union members list, name of the union members are drawn, but in reality, sometimes they do not pay the union dues. So, in this case, this union membership is real or not. It is so questionable. And so, this is the big problems. Under the secret ballot, there is big problems. Free rider occurs. Union members must pay the union dues, but the non-union members do not pay union dues. But under the secret system, the non-union members can participate to the secret ballot. They have the right to vote which unions are chosen. But so free riders is a big problem under the secret ballot. Yes. Next, please. Debate over issues of bargaining. Under the collective bargaining, typically wage levels is a big target for the bargaining collectively. But in this issues of bargaining, big problem is the management prerogatives issue matters. For example, one company want to build the new factory. This point is management prerogative matters. But if the new factory will be built, workers must move to the new factory from the old factories. So sometimes they must move their address, home. And so this is a big problem or the working conditions. So management protectives have relative to the working conditions of the workers. So, management prerogatives matters can be decided by only companies. But in relation to these problems, working conditions are influenced by the management prerogatives matter. So, in this point, this is the target of the collective bargaining. So, in Japan, besides the collective bargaining, joint management committee or consultation system was introduced in Japanese companies. This committee has a purpose to exchange opinions between the employer and the labor unions and also employees. So, in these committees, sharing information or exchange opinions is held. And so, they can communicate it with each other. So, labor unions and the employees can understand the idea of the employer. So, this brings amicable industrial relations. So, next point is a problem of low union density. In Asia, union density is very low. In Japan also, 16%. And Indonesia, I think about 10%. In Asian countries, Singapore is the highest union rate, 23%. So in Japan, 84% workers are not organized into the labor union. And so in case of no labor unions, work rules are important to decide labor conditions. So, in general, work rules are regulated unilaterally by employers. And so, I think that in Indonesia can be seen under the same conditions. Work rules are regulated by the employer. So, minimum wages have a big role to survive lives of workers in non-union organized union or labor unions also. So, minimum wages are covered by all workers. And so whether workers are organized or not into the labor union. So minimum wage is a very important issue. So the role of collective bargaining becomes very smaller and smaller in Asian countries. Yes. Yes. Next, please. Yeah. Settlement of labor dispute. Yeah. Labor disputes are divided into interest dispute, typically the level of wages, and also right dispute, workers' right dispute. And another another division is individual dispute and collective bargaining. But so 4 types dispute are categorized. But this dispute cannot clearly divide it. So individual dispute, for example, the dismissal of one worker. But this one worker dispute problems is collective token by the labor unions. Sometimes labor unions participate into the dispute of only one worker's dismissal. So in this case, this is named as collective dispute. So, for types dispute is not so clearly discriminated. So very mixture, yes. Hey. So, to settle labor dispute, tripartite mechanism are organized to resolve the interest dispute and collective dispute. Government, employer, and labor, three parties, members. So, conciliation, mediation by the administrative bodies is made in Asian countries. So, in this conciliation, mediation, third party will persuade both parties of dispute into the amicable resolution by presenting alternative resolution. This is the key point under the conciliation and mediation system. Hi. Next type is arbitration. Voluntary or compulsory arbitration are involved in the arbitration system. In arbitration process, argument of both parties are heard and arbitration award shall be issued. Usually, award is not legally binding on both parties. So, in Japan, labor dispute may be referred to the arbitration process. This labor dispute shall be finished to the final resolution. But I find that in Southeast countries, arbitration does not lead to the final resolution. If the parties may not approve the award issued by the arbitration process, the party can appeal to the dispute or appeal to the award to the next step. For example, labor court or industrial court. So, in South Asian countries, arbitration process practically plays the same role of the mediation. I have a question. This finding is correct or not? はい。じゃあ、next please. はい。はい。next labor dispute at a civil court or special court. Right dispute may be referred to ordinary civil court or special court. In Asian countries, labor court or industrial court are organized. So, labor court is composed of the professional judge and representative member from employer and labor unions. So, this is the tripartism system. So, in Japan also, district court is composed of the professional judge and representative members from employer and labor. Only under the district court, only tripartism system are introduced to deal with the labor dispute, labor rights dispute. So, and the next point is very important in South Asian countries. Informal resolution is a very big power to resolve the resolution. For example, by police, influential person, both of the district, elders or authority figures in local communities. These people have have a big influence to resolve the dispute, including labor dispute. I think the environmental problems is also the same situation. I think so. So this point is a big point. So I want to know the Indonesian cases. And also dispute resolution with the help of NGOs in informal sectors. So collective bargaining and labor dispute settled at the only formal sector workers. And so informal sectors, labor union or labor laws cannot intervene to the resolve dispute. And so informal sectors dispute, NGO participate to resolve the dispute. It is big point. Hi. So next point. Sorry. Hi. Strike and lockouts. Strike and lockouts stop production process and lower productivity. And so strike is approved as the last resort from labor side. And so strike is defined as the refusal to provide work, although labor contract continue during strike period. And so lockout is also defined as refusal to receive work provided by workers. So under the labor law, strike procedure is regulated. Strike ballot and the notice of strike is regulated under the Labor Act. And so this is a big point, is wages during strike period. In South Asian countries, no work, no pay rule is not always kept. This is a key point on the wage during strike period. Husband and wife quarreled. So, if the husband did not brought his salary to his wife, so his wife has so troubled to survive their lives. So during the quarrel between husband and wife, they must get some level of money to survive their lives. So industrial relation is similar to the relation between husband and wife. So I think so. So in South Asian countries, no work, no pay rule is not always kept. I think the Indonesian Manpower Act provides some money will be paid during the strike period. And so in Japan also, the same idea is adopted. So wages are divided into sides where one is a wage payment to the status of employee, and one another is wage payment to receive the workers, present workers provided by the employees. So status and the present work roles. So as the status of employers, so house allowance must be paid even during the wage period. But the load of the work or the burden of work must not be paid even during the strike period. So, two sides of wages are divided into the in relation to the wages during the strike period. And so, for some cases, some monies are paid to labor unions as the condition to resolve dispute. So this some money will be paid to the labor unions, and the labor union distributed the monies into the union members. So all the wage amount cannot be paid to the union members, but some money can be paid during the strike period. Yes, hey. Next point, conclusion. Yes. Industrial relations are not one of the keys to achieve sustainable development. Prolonged labor dispute hinder productivity of enterprise and have a negative impact to sustainable economic growth. So it is difficult to continue labor dispute forever. So they must stop sometimes. Above all, after the end of labor dispute, an employer and their employees had better maintain good industrial relations. This is the key point to achieve the sustainable growth. So, amicable industrial relations must be promoted in Indonesia also. So, to promote amicable industrial relations, Japanese Committee of Metal Workers Federation has initiated workshop in Indonesia to build amicable industrial relations in Indonesia around the Jakarta. In Indonesia, workshop was held 10 times. In this workshop, management and the labor side both participate to the workshop. So, Japanese Committee of Metal Workers covered the steel, automobile, electric shipbuilding, machinery, electric cables. And so, total members number is about 2 million members. So this union participated to organize the amicable industrial relations in Indonesia. So especially Japanese companies operating in Indonesia must try to make the amicable industrial relations among Indonesian workers. So this is my conclusions. So thank you so much.
Thank you very much, Professor Kagawa, for your insight materials. I think we know about how the labor unions operated in Asia context. I think two roles of the labor unions, not only cooperative side as well as the conflictual side, how to protect the workers. So maybe we can discuss later when you can ask question for Prof. Kagawa as well, Dr. Andreas previously in the next discussion. And now I like to invite Ibu Mia Siskawati PhD that she will give the materials regarding the gender perspective. But before she present the materials, I will read the experience of Mia Siskawati, holds PhD in anthropology from the University of Washington, USA. She's lecturer and the head of the Gender Studies graduate program at the Graduate School of Sustainable Development, Universitas Indonesia. Her expertise covers feminist anthropology, feminist ethnography, feminist political ecology, feminist agrarian studies, gender and environment, gender and natural resources, gender and forestry, gender and land tenure, gender and development, and gender and human rights. He has participated in several international collaborative research projects and is actively involved in international professional associations. She also has served as a council member of the Asian Association of Women Studies since December 2019. She also has served as board member of several Indonesian non-governmental organizations working for women's rights, environment, and democracy. So I think, Bumia, time is yours, 20 minutes. Please come here and...
Thank you, Dr. Iren, for the very nice introduction. Ladies and gentlemen, thank you for the opportunity, especially to Professor Mizuno, for sharing. This is part of my long-term study, and specifically on the sector of oil palm. So when Professor Mizuno invited me to share about the topic of labor conflict resolution, so of course, then I'd like to propose focusing on the case study of oil palm plantation. I'd like to start with a short video, and this short video actually taken as part of our collaborative research. So collaborative research between Universitas Indonesia and the International Center for Forest Research. Please.
Sebelum ada perkebunan kelapa sawit, hutan semua di sini. Dulu kan masih enak orang itu cari sayur, cari ikan, beladang, itu apa, cari berburu, cari binatang kan. Dulu kan masih banyak, sekarang ini tidak ada lagi. Ikannya masih ada, cuma itu binatang-binatang lain agak susah dapat sekarang nih. Nama saya, nama lengkap saya Madalena Pandan. Umur saya 35 tahun. Pekerjaan saya sehari-hari perkebunan kelapa sawit, yaitu pertanian. Ini mau sekolah nanti. Pakaiannya harus dimasukkan dulu. Saya bangun pagi jam 3 subuh, yaitu saya berangkat noreh, yaitu langsung masak. Udah masak, saya nyiapkan barang-barang saya, makanan saya, minuman saya. Udah itu saya mandi. Udah mandi, saya beres-beres tuh anak saya yang baru usia 5 tahun 9 bulan tuh, dia udah mau berangkat ke sekolah. Selesai gini, baru santai-santai kita nunggu itu jemputan datang. Emang sih rasanya agak capek, tapi apa boleh buat lah, saya kan udah punya anak sekolah. Yang satunya kelas 2 SMA, yang satunya baru kelas 1 SMP. Apa boleh buat lah, karena bapaknya kan mengharapkan cuma bapaknya cari uang, pekerjaan di sini tidak mampu, dia sendiri carinya. Makanya bantu dia tuh cari uang untuk membiayai anak sekolah. Biarpun capek, saya tetap bangun setiap hari itu jam 3 subuh. Untuk saya cari uang untuk nyekolahkan anak, untuk makan minum, untuk apa-apa aja ya. Setelah saya udah ngantar anak saya sekolah, jam setengah 6 itu saya berangkat ikut truk ke tempat PT saya tuh. Pupuknya mulai dari jam 8. Udah itu istirahat jam 10 kurang. Istirahat minum. Udah itu istirahat makan jam 11. Jam 11. Udah itu berangkat lagi pupuk. Selesai enggak selesai sekitar jam 12 lah. Gaji saya cuma 86.000. Enggak mencukupi sebenarnya. Apalagi kan untuk biaya anak saya terus sekolah kan tidak mencukupi sebenarnya. Kan BHL kan tidak bisa lebih dari 20 hari itu. Tanggungan apa-apa kan tidak ada kalau BHL tuh. Perempuannya ada juga laki-laki gabung, bisa juga laki-laki. Tapi kalau perempuannya cukup, laki-laki tidak diambil, cuma untuk lansir aja masuk ke dalam. Itu. Target saya itu satu hari itu 300 kilo, satu pokok itu 2 kilo. Setelah selesai mupuk, tangan saya rasanya perih, apalagi luka-luka kayak gini. Rasanya perih sekali. Kalau udah lama-lama enggak itu dari cuci, enggak terasa lagi perihnya. Udah kayak biasa lagi. Takut sih sebenarnya, tapi enggak itu enggak bisa ngambil pupuk cepat-cepat ke tempat itu, makanya enggak pakai sarung tangan. Sebenarnya saya enggak mampu lagi ke depannya sebenarnya, rasanya enggak mau lagi. Tapi apa boleh buat, kalau enggak ada kerja lain kan kita pergi ke kebun kelapa sawit lagi. Sampai ke rumah itu, kalau ada kesempatan ladang yang nanam padi ini, saya umur padi saya baru 3 bulan. Sampai ke tempat panen nanti sampai 6 bulan. Hasilnya enak yang di tani ini. Enaknya apa, kalau kita kan di tani ini kalau dapat padi banyak kan kita tidak beli beras lagi. Saya sekolahkan anak saya ke depannya supaya anak saya jadi orang bagus. Saya tidak ingin anak-anak saya kerja seperti saya nih. Supaya ke depan dia bisa bagus.
So thank you. That's the short documentation of a one-day experience of one female worker of the oil plantation. She's not a migrant worker, so she lives in the village nearby, and part of the oil palm plantation that nowadays managed by the big company, actually part of her ancestors' homeland. Anyway, so I'd like to start with the palm oil industry. This is such a huge industry for Indonesia now, and Indonesia is always competing with Malaysia. This is the latest data. Indonesia produced around more than 55% of the total production globally. However, although Indonesian government announced that in terms of the foreign investment, I mean, the income for Indonesia, oil palm really benefit Indonesia. But in terms of the oil palm plantation workers, they still face problems of worker rights protection, safety, and welfare. So the example of Ibu Magdalena that you saw in the video, she could still, although she's facing many difficulties, she still live in the village. But for the workers who live within the plantation area, they live in a very, not a very good condition. Next slide, please. So the types of oil palm plantation in Indonesia, there are 3 types actually. So corporate industrial plantation. This is the plantation where the Ibu Magdalena you saw in the video work with. It's a private corporate industrial plantation. There's also state-owned industrial plantation. There's also privately owned small-scale plantation. In Bahasa Indonesia, we call kebun rakyat or the people's garden. Next slide, please. Next, I'd like to enter the discussion on the gender dimension of the violation of the workers' rights and also the human rights. I start with the type of the non-permanent workers of oil palm plantation, which actually the number is quite big. So number one, the first type is called temporary contract workers or buruh borongan. So mostly men, and they actually usually involve in the preparation of the land. The men who are contracted as a temporary contract workers usually help by their children, by their wives. The children and wives actually work for free. So they also work, but the company only contract the men. The second type, known as buruh harian lepas in Bahasa Indonesia. So in English as casual daily workers. This is the daily workers with the daily wage. Mostly women, like you saw in the video. They mostly having the task of spreading the fertilizer or spraying the pesticides. And what is interesting is also stated by Ibu Magdalena in the video, because they are the casual daily workers, they only can be working for 20 days a month, because that's according to regulation. And according to regulation, actually, they could only work maximum for 3 months. But in Indonesia, they work for longer period. And for the case of the women workers, usually they will be fired when they get pregnant 7 months. And later, the company could hire again after the child more than 2 years old. The third type of the workers is called kernet workers. This is the assistant of either the assistant of the temporary contract workers, or sometimes also the assistant for casual daily workers that have the bigger task. These kernet workers usually is not really like having a formal contract with the company, but they are there. Another type is forced labor. The forced labor, they could work as a temporary contract worker, casual daily workers, or as a kernet workers. Was it forced labor? Like they are recruited usually as a family, so husband and wife and adult children, and like as a group of workers, they are financed by someone. It's part of the mafia, a labor mafia, and because this mafia finance the transportation and all costs, including the cost of paying for the brokers, labor brokers. So these workers, they usually do not receive wage for the certain period of time. Could be 2 years. The longest period of they did not receive payment that I met in my field research is 5 years. So during 5 years, they did not receive any wage, and what they did to survive is they were trapped into debt bondage with a certain group of people who lend them money. Another type is child labor, and this is the child labor is usually the children. So this is the individual under 18 years old, because Indonesia already ratified the UN Convention on the Child Rights. So individual under 18 years old considered children. So they usually also work to help their parents, not just helping after school, but many of them actually do not go to school. They do not have access to education. Why? Because the workers who live inside the plantation, not living in the village nearby the plantation, they have a very limited access to school, because going to schools in the nearby village need like transportation, and also need some documentation that many families of the migrant workers could not provide. Of course, then there's also predatory practices, including like debt bondage, that can also continue the forced labor. Next slide, please. I'd like to talk a little bit about the child labor in oil palm plantation. This is usually start with the adult, either adult temporary contract workers or adult casual daily workers being helped by their children. Then actually these children who work as child labor are not registered. And many companies nowadays like really careful about this, but in reality, in the field, we still we see like in certain contexts the child labor, poverty situation of the workers, especially the migrant workers, coming into the plantation and work in inside the plantation. They live inside the plantation, contribute to the emergence of the child labor. Also, the limited access of education, as I mentioned. Then the child marriage practices that also still happening now within the family of the oil palm workers, especially those who live inside the plantation, then actually also produce child labor. Next slide, please. Next, I'm going to talk about the gender dimension of oil palm labor conflict resolutions. So labor conflict resolution in the context of oil palm plantation usually mediated or managed by the labor union. They play very important in the labor conflict resolution. However, I'd like to continue what Professor Kagawa already mentioned in his findings, that actually, like culturally, the labor union, such a, it's like not a new phenomena, but after the tragedy of the 65, so started with the New Order era in this 1966, labor union activity considered as the leftist activity. So the activity of labor union is like finally accepted by the government. Is like in post New Order. So after 1998, and after 1990, of course, the labor union, they worked so hard to be accepted by the company. And what Professor Kagawa mentioned is already also happened in the context of oil palm plantation in Indonesia. And because such a not new, but the re-emergence of the labor union after the tragedy of the 65 tragedy, of course, then some labor union is still struggling to be accepted by the company, and some labor unions also do not include non-permanent workers. However, some others, they include the non-permanent workers, like I mentioned, like the temporary contracted laborers, the casual daily laborers, and some other non-permanent workers. But the women workers, including those non-permanent ones, actually still limitedly involved in the labor unions. Why? Because many labor unions in the context of oil palm plantations still dominated by men. Although now many labor unions started to involve the women's workers. In addition, many labor unions have limited understanding about the dimension of gender equality and social dimensions. They already trying to recruit women workers as members of the labor union, but they have not yet adopted the perspectives of the gender equality and social dimension. For example, for the women workers who work as casual daily workers, they are not permanent workers. Of course, their protection of the reproductive health, for example, during menstruation, I mean, they are not protected because there's no bathroom in the plantation. So, and many women workers in the certain areas, they have to do spraying the fertilizer in the muddy areas, and during the menstruation period, of course, it is very, very hard for them. So these issues and the other issues of like the rights of their reproductive health of the women's workers not yet part of the conversation of certain labor unions, although some other labor unions started now to learn and to adopt. So next slide, please. So it has become the homework of academic research, as well as, of course, then the collaboration of the academic researchers and those who work to protect the rights of the workers of the oil palm plantation, including the women's workers. So we need further research on gender and social inclusion dimensions of prevention of violation of workers' rights, as well as violation of the human rights in oil palm plantation. And also we need further research on gender and social inclusion dimensions of oil palm labor dispute or the conflict resolution. This second part, we need actually to do more research and more collaboration between academic researchers, academic institutions, non-governmental organizations, and labor unions. Next slide. The recommendation for government. So it is very critical now for the government of Indonesia to strengthen protections for oil palm workers, including standardized contract, procedures, increasing oversight of recruitment agencies, and banning workers' paid recruitment fees. And if the government really do a law enforcement on this, the so-called forced laborers or the other type of illegal workers could be avoided. Also, government needs to issue specific protection regulation for oil palm and other industrial agricultural workers. Why? Because oil palm labor unions and some other labor unions in agricultural context mentioned that the law on the employment law of Indonesia is not enough for the protection of the oil palm and other industrial agricultural workers. Next slide, please. This is the last slide. So actions needed, especially this is for government, for companies. The oil palm companies should seriously adopt and implement gender equality and social inclusion principles. They do adopt in the paper, but do not really implement in the field. This is I've been doing field research, staying in the oil palm plantations for 2 weeks. The longest period, I think, is almost 1 month in the field, and I have also published certain articles about that. Companies should also ensure a reliable, efficient grievance mechanism in the workers' native language in present throughout the entire supply chain. And major oil palm industry stakeholders such as Wilmar International should take a forceful stance against the worst forms of forced labor and child labor and eliminate practices that facilitate it. The RSPO is the Roundtable for Sustainable Palm Oil, should implement regulations into the certification criteria requiring assessments of conditions at the plantation level, so not just like at the policy level. It should begin by requiring companies to prove that they have undertaken human rights due diligence on third-party sources of palm oil. Thank you.
Thank you, Ibu Mia. It's very interesting presentation and also video. And I think, the point is women still limited involved in the labor union. especially in the plantation industry. And I think we need to emphasize about the collaboration, multi-parties, academia, NGOs, other industry stakeholder, and also government. So and next, we like to invite for the speakers, but I like to announce that I really appreciate that anyone that joined directly in the middle of heavy rain, multiple heavy rain, I really appreciate that you can join directly to this room, and as well as the 57 online participants that joined in this event, and some of them already give some question. So I invite maybe during the presentation of all the speakers, you can put your comments or question maybe at the chat box, and then we will discuss it later after all the speaker present. So for the third presenter or speakers, I invite Professor Kosuke Mizuno. He is adjunct professor in our School of Environmental Science, Universitas Indonesia, but previously he is the Professor Emeritus from the Center for Southeast Asian Studies, Kyoto University. I think many experience of the academic publication, especially the recently books is about the 2 centuries of agrarian, economic, and ecological shifts in the north coast of Java, 1812 until 2012. And also about the vulnerability and transformation of Indonesia peatlands. Another book is about democratization and industrial relation, industrial dispute, settlement based on musyawarah, and the origin of activism in Indonesia. So I think without further ado, please, Professor, you can present about the materials.
Yeah. Thank you very much. I would like to discuss on the land law and dispute resolution in Indonesia among musyawarah, mufakat, mediation, and court ruling. Can you show my point? Yeah, thank you. Next, please. Yeah, so as I have shown, in Indonesia, we see the judicial dispute solution and the ADR and musyawarah mufakat. The 3 methodology operating. So, but how these mechanisms, these approach are functioning in the concrete dispute settling. So I want to show a case study at Padang Island, Riau province. So we have done the field work in 2023 and 4 with our friend Pa Dianto and Pa Pandu and so on. And Padang Island is located. Next, please. Next, please. Sorry. Padang. Next, please. Next, please. Yeah. So put. Yeah. Padang Island. The island located between Singapore and Sumatra, and this island has a history of timber logging industry since the end of 19th century. Slide before. So here, number of population is not many, but Malay, Japanese, Bugis, Minangkabau, Batak, Chinese there. And we have done the field work. So among them, the Malay, Japanese, Batak, and Akit, and so on. Next, please. And next, green is peatland. So this area is peatland area. Next, please. This is Padang Island. And next, please. So on this island, a company got the industrial forest concession from the government covering 45,000 hectares. And government company start the operation in 2009, but that caused huge unrest among the people because people have stayed there. So there is a conflict between local people and the company. And the local people took the action, mobilizing a lot of people. They have demonstration, they have mass meeting in front of the district head office or province governor's office, even in Jakarta, in front of the Ministry of Environmental Forestry office. And they demand that company get out from the island. They demand that is their own land, not the company land. But first, initially, many local officers are sympathetic to the local people. But finally, government backed the company on the local government officer also backed the company. And the Ministry of Forest said there are no people in Padang Island. People these action are not the people of Padang Island. So there is a implication that they do demonstration are immigrant, not the original people. So no original immigrant don't have the customary right. Original people have the custom, but the original people don't do the action that like that one. Fine. Next, please. But 2011, government minister order to make the mediation team. And the mediation team, with about 1 month or 2 months, issued the report. And the report is well organized or take it account many factors like the customary right and so on. And also recommend the principle of free, prior, informal and concept FPIC to the stakeholder, especially the company. And show the next please. And show two options. Pull out the Padang Island from the pull out the Padang Island from the ministry decision. That means the cancel the company's right of industrial forestation. And the second option is to reduce the area of concession. And finally, government issued the decision that reduce the area. This is next please. This is the island map. And next please. Now this is red part is the industrial forest concession, original one. And the next, please. Now the somewhat here. This is not the red one because this one is created from the concession area. Next, please. Next, please. So from this chronology, what can we say? Now, when we did the interview with the farmers union leader, why don't you bring the case to the court? Because you have land right. Yeah, but they said bring the case to the court is quite risky. We can be defeated, and if we are defeated, that becomes an excuse to erase their land right. And we don't have much manpower or much ability to compete with the layer from the company. So they do the mobilization of the people to protest the company with a hunger strike, or for example, until they stitch their mouth. Their mouth was stitched. That was quite sensational. So the issue was reported by the mass media or paper and so on. So those direct action bring the change of the attitude of the Ministry of Forestry. Next, please. And a meditation report was issued, but most important event is that February 13, 2013, a leader of farmers union met the person from the company, and they agreed. First, company canceled the accusation to the member, and other agreement was not disclosed. That is somewhat, yeah. But anyway, with that agreement, the action reduced, almost become calm. So this process can be said as musyawara mufakat. Musyawara in Indonesia is of course the dialogue, that is musyawara. But actually, actual musyawara process in accompanied with the mobilization. When I interviewed with Iqbal from the Metal Union or KSPI, or now the president of Labour Party, he said, if we when we negotiate the company or the company or the state with that mobilization, they will not hear us at all. So we should mobilize 1,000 people. 1,000 is not enough. So 10,000 people should be mobilized. With that way, they will hear us. That is the logic of negotiation or musyawara. So with that, this case also, with mobilization, 10,000 people have demonstration until stick the mouth. Finally, they got the concession from the state. And once they agreed, mufakat, that can become the calm. Now that is a real process of musyawara mufakat. Musyawara mufakat is accompanied with mobilization, sometimes violence and criminalization, and accusation and chasing and so on. That is the process of musyawara mufakat. Now, So we see that process of musyawarah mufakat. And next, and sorry, one before, one before, and this in this process, mediation was effective. Minister ordered the form of mediation team, and the mediation team issued a quite good report. We read, and that is that include many data, many information, and some we can say that is neutral, and some many of the recommendation was implemented, like the prior informed and concept. That was effective after 2021. Page office was being involved, so the transaction was transparent. Beforehand there was a land mafia, but now no land mafia. That is process. Next, please. Yeah, but we do survey on the land right. Now, actually people have the land right, customary land right. Next, please. Now, here the area. Next, please. Next, please. Yeah. Now the area is Kawasan Hutan forest area. That can be said state land, state forest. But that is only since 1986. Beforehand, the land is controlled by the regime of customary right. So many people say when the island around this around before beginning of 20th century, there was a pandom business there. Singapore businessman mobilized worker from Java Island or China or Singapore and so on. So those people are brought to the island and they stay there. Many Japanese have a long history living there. So a person said they are offspring of ancestor of 5 generations before, like that one. So people think that is state land, so they cannot compete, and those messages is prevailed during the conflict. That's why people think that they cannot compete relating the land right. It's better for them to mobilize the person with mobilization and do the hunger strike, stitching the mouth and so on. That way, government doing concession to the local people. But actually, next please. Actually, we do the survey on the letter that certificate the land right, and the former letter is only two times, but there are many other letters that show the customary land right. Next, please. So, actual process was musyawarah mufakat involving the mobilization, hunger strike, criminalization, or chasing the person and jail and so on. But mediation was effective at the process, and the judicial process was not there. But actually, people have the aspirant right, so this process can exist there. It is a process that not always until the body with test can be brought. It's a process in the court. Judge can recommend you to negotiate, recommend you to bargain and so on. So based on the right that people have. So one idea is that the hybrid one can be solved. One idea is that people put property right, while the company can secure its right based on the expropriation. Maybe, yeah, that is one idea. So, musyawarah mufakat is a traditional way, and that is effective, and sometimes that is very militant and very powerful, but involve many violence or criminalization or or hunger strike and so on. So because of those practices, we find many many conflict in Indonesia. Yeah, so we can find as a good way, wise way of hybrid that have combination with three approach. That is my conclusion. Thank you very much.
Thank you very much, Prof. Mizuno, for the informative presentation. And I think from your presentation, we know the hybrid process also become one approach for the dispute that happened in Indonesia also. So for the last presenter, we have Professor Yuka Kaneko. She is from the Center for Social Science Innovation, Kobe University. So her academic fields is in Asian law studies, law and development, land law, disaster law in Asia. I think so many lists of her publications, but I will read for the recently publication. There's a Horizon of Law and Development Studies 50 years after Japan. 50 years after, that published in Japan Society Sociology of Law, and also titled Introductory Note on the Revival of Customary Rights, an Implication from the Post-Disaster Eviction Case. And the last, the updated one, the last publication is about forestry management and customary rights in the development, a legal review of forestry disputes in Indonesia. I think she also became a membership, many membership of academic societies, Asian Journal of Law Society, Japan Society for Sociology in Law, and many organizations more. So without further ado, I invite Professor Kaneko to present your materials. Thank you.
Thank you very much for the kind introduction. It's my great pleasure to be here. I first like to express my special thanks to the organizers for this very precious opportunity for us to exchange views. As already kindly introduced, I belong to Kobe University. Kobe University has been dedicated to the sustainable development. And more than 30 years ago, Kobe University has established Graduate School of International Cooperation Studies for this purpose. And recently, Center for Social System Innovation has been established to contribute to the aim of sustainable development from interdisciplinary approach. And I myself is specializing in law, Asian comparative law. And yes, and as shown, there are a number of books I wrote in this field. And then some of which I'm going to dedicate to your dean later on. And and our method make much of the field work in order to observe the actual phenomena of law in action. Even during this trip, Professor Mizuno will kindly take us to some dispute site in South Sulawesi after tomorrow, and then we really expect to learn a lot from this trip. And today's topic is land and forestry disputes. But due to the time constraints, I cannot cover many countries from Asia. I want to concentrate on Indonesia law first. Based on my limited knowledge of Indonesia law, I'd like to confirm some of the issues. And then I'd like to introduce some situation from Japan. And we understand that in Indonesia, one of the most essential questions of land and forestry dispute is whether the customary collective land rights, hak rakyat, can contest to the national forest area, Kawasan Futan, as Professor Mizuno introduced in actual case from Padang Island. And of course, procedural approach is very important. As Professor Mizuno mentioned too, pre-informed prior consent is very important as the procedural basis to realize the rights. But in the same time, substantive issue is very important from the viewpoint of the law to establish the right, the contents of the right firmly to be accepted by the dispute resolution procedure. And to this sense, I believe we should first start with identifying the nature of rights. Particularly, we should differentiate the typology of different types of hak rakyat. Perhaps some of them must be very strong as ownership, but others are not. And some of them must maintain strict collective rules, but others have been individualized into hak milik adat. And some of them often being secretly transacted, sold to investors, without going through with the formal way of transactions, nor a traditional way of transactions. That's why they often lack the evidence, documentary evidences, as well as oral type of evidence. And even when we focus on the most firmly established type of hak rakyat, still state public law tends to ignore such regime based on the logic of state control rights under Basic Agrarian Article number 5. And therefore, our question is very clear: how we can strengthen the legal status of hak rakyat under the public law so that the state cannot ignore it, but needs to pay respect lawfully. For that purpose, many attempts, still keep the previous page, the Indonesian law have been attempted many approach. The most popular approach must be to establish the hak rakyat as the adat forest, Futan adat, as an independent property from different from national forestry, which is as recognized by the Constitutional Court judgment in 2013. But to seek this approach, the procedure of adult forest registration has been the main obstacle, as you know, which I like to discuss later slightly. And on the other hand, the Indonesian government promotes the social forestry system, but such systems only usually only allow the limited type of servitude rights. And I tend to think about other modes of protecting the hakurayat under the legal system. And one of my thinking is that if you create hakguna usaha on state land to be held by adult communities, I think this can be a stronger real right rather than the mere servitudes. But I don't know this is practically possible under Indonesian law. And another way might be to constitute hakurayat as a public property rights of local autonomous community unit under the local autonomy law. This is one approach often taken in Japan. But I don't know whether Indonesian law accepts such possibility. In any case, the problem is the proof of existence of hakurayat. This is a headache, as all may know. Even when you intend to apply for the adult forest registration, you need to prove many elements. And initially, under Ministry of Agriculture Regulation number 9 in 2015, the proof was the continuous land use for 10 years. But this regulation has been taken over by Regulation number 18 in 2019, which required the recognition of adult communities under the Ministry of Interior's Regulation number 52 before the urayat land registration is applied under Government Regulation number 18. And also, 20 years occupancy has to be proven under Presidential Decree number 88. So many requirements and very difficult process was in there. But very recently, since 2024, a new Ministry of Agriculture Regulation number 14 has been introduced. And now you can choose among 3 different options. First one is urayat land registration, Defta Tanah Urayat, without obtaining adult community registration first under the Ministry of Interior regulation. This is a difference from the previous system. And second one is a new type of filing system of urayat land management rights. This doesn't need to apply for the adult community registration first. And the third one is the new one, which is the approach that community group to apply for co-ownership as hakmilik under basic agrarian law. So hakurayat can be registered as hakmilik of one group. So these 3 options has been given by the recent regulation, but how they are being implemented and what are the popular choice among them is my question. And if you can give me some input in this regard, or if you know someone who is studying about this topic, I really appreciate your input. And next, please. ちょっとその前に previous page you have? Only this? The next one, please. そうか。Sorry, actually I inserted one more slide in here, but this older version shown here. What I discussed is the hakmilik to be registered under the formal system. But I suppose actually majority of hakurayat might have not yet been going through with such registration procedure as adult forestry. So we have to think about a solution for non-registered hakurayat. And so for this purpose, in other words, we have to think about which dispute resolution system, which dispute resolution forum apply what kind of norm? This is my concern. So in this regard, if you go to the court may simply apply the formal law. And then they only refer to international norms just as a reference. And if you go to the mediation, as Professor Mizuno discussed, mediation, we may expect the mediators to apply customary law more flexibly than the court. But you cannot assure it. And then rather, there must be some risk that the mediation can be manipulated by biased type of mediators as a means of controlling the people, controlling the society. This is actually the question which has been raised by Western observer on Japanese mediation. So I'd like to know the real nature of mediation in Indonesia, how they are functioning, as in the case of Mizuno Sensei's Padang Island case, what is the fact behind the hidden, hidden result. And then I thought Professor Mizuno will touch on the market-based approach, not only the regulatory approach. Nowadays, the EU is very eager to introduce the disclosure system and also the due diligence framework to oblige the large brand companies to be responsible for to take the action to improve the program of environmental social issues based on the contractual pressures. And then if I was allowed to have more time, I could want to mention to that. But here, the slide shows the issue of mediation. As I said, Japan is highly mediation-oriented society. And more than 40% of civil disputes in Japan is said to be settled by civil mediation system attached to the court. And another 30%, nearly 30% of such civil disputes is settled inside the court. The court doesn't, during the litigation, court doesn't give the judgment, but instead invite the parties to the settlement room and then try to settle the case. So that is Japanese style. And then actually the mediation is very popular in Japan. Arbitration never. Why mediation is popular? Because parties can have a certain degree of initiative, and also the quality of fact-finding in Japanese mediation is quite good. Compares to litigation. Litigation is only done by the judge, lawyer. But in mediation, systematized mediation in Japan, not only judge, one lawyer and two experts from the individual industries. If it's a case of construction case, then the construction specialist will be invited as mediator. So this kind of very expertise setting allow the very high quality of fact finding. So this is the reason of popularity of mediation in Japan. But there are still a lot of criticism as well. As I introduced a little bit already, the foreign observers is very critical about Japanese culture of based on the mediation. Okay, hi. Could you go to the next slide? So in either case, I believe that the reform of formal law is very important. Especially when we think about the legally enforceable conclusion to settle the dispute firmly. This is a lawyer's goal, stable conclusion we want to seek. Then, what should be the formal law? I understand that World Bank and then FAO has been suggested to establish the uniform registration system to formalize hak rakyat. But many Indonesian people are cautious about this idea, which may only result in the buy and sell of communal land. So in this regard, let me introduce Japan's experience. Japan's civil code has explicitly recognized idiaiken, customary collective land rights, just similar to Hakurayat and a basic agrarian law in Indonesia. But Japan's civil code is different from Indonesian basic agrarian law in the sense that the Japanese law doesn't require the mandatory registration. The registration system we have, but it's not mandatory. So most of the iriaiken, customary collective rights in Japan are unregistered, and it's totally lawful. This is such system has been maintained nationwide. But of course, when the unregistered iriaiken faces with a contest of nationalization, it needs to have more security. So what are the means of security? In this regard, in Japan, Supreme Court of Japan has established plenty of case law. And such case law development was made possible because of the contribution by academia. Academia accumulated the study of individual disputes and then induced the essence from each such dispute, and then place such argument at the court. And the result of such dispute resolution has been accumulated into the Supreme Court case law. That is the way Japan's protection of iriaiken has been increased, has been strengthened. That is the story. But problem is being occurred recently because Japanese government turned to neoliberalistic, and then now Japanese law is has been amended to reactivate the economy through land redevelopment. And for this purpose, a series of law has been introduced recently to enable flexible land use by ignoring the iriaiken unregistered collective customary land use and right. So our question is in response to this. Sorry. Actually, I included some pictures, some slides to show the picture of our fieldwork to identify the response. Our fieldwork results from north part of Hyogo Prefecture to, but it's not included in the document, so sorry. I just wanted to show some slides to show the environment of local rural area in Japan, and then the people, communities have been stand up to protect their iriaiken right. Actually, Japanese law. There are many slides skipped in here. Please don't. Please come back to this. There are many legal ways to strengthen the status of iriaiken in Japan. The one is the registration as co-ownership in the name of the community members, just to included as one of the options in your 2024's recent regulation. But another way is to establish one group, community group, and then let this group to register iriaiken as single ownership. And so what kind of legal group can apply for this single ownership is a question. There are several options. And one difference among such several options is the decision-making system. And then iriaiken in Japan has been featured a consensus, similar to Mushawara Mufakat. All members in one community has to say yes. Unless all consensus, nothing can be changed. So such stability has been the characteristic of iriaiken Japan. But if you choose to establish one group based on some institutional framework, then it will be changed. But there are many options, like Zaisanku, and then 生産森林組合, the forestry association, cooperatives, etc. There are several choices. And then decision-making system differs. Well, some of them based on majority voting, and some of them based on local assembly style, public democratic style. So you have choice. So my implication is that maybe your hak rakyat vis-a-vis state control rights under the basic agrarian law, Article 5, can also be changeable. And then our Japanese implication is that if you give the choice to the community people, they can choose a better fit for one for their reality. If they have firm basis of consensus, they may choose. If they come to Japan, they will choose the Ninka-Chien Dantai. But they may have different choices. So, and then so could please go to the next slide. I know there is no time. So I wanted to mention to the possibility of market-based approach, and then that nowadays EU under the Green Deal very much promoting the thinking of disclosure and then due diligence approach. And then, but actually they are facing a lot of difficulties. So I wanted to describe the difficulty they faces, but due to the time constraint. And then also ASEAN. Yesterday we visited ASEAN headquarters and then make interviews for 2 hours. They gave, and then even the Deputy Secretary General answer to our questions. And then ASEAN is also eager for this disclosure based on ASEAN taxonomy, but the target is limited. The normative basis are only ASEAN declarations. And then if you turn eyes to United Nations and the ILOs and the OECDs, all such bases look fine. But actually, every time of revisions, they are narrowed. This is the reality of this line. So, yeah, this is my, so please go to conclusion. Yes, please skip. I couldn't have time for it. UN, ILO, yes. So conclusion. Formal law matters. So after this, I like to join with Ms. Sensei's trip and then try to identify what is the choice of local people, what is their needs for the reformation of formal law. Thank you very much for your attention.
Thank you very much, Professor Kaneko. Sorry, maybe we can continue while discussion later on. But since we are running short on time, before we proceed for discussion, I think our research manager like to give some closing remarks because he will have another important meeting also with the university. So I invite Ibu Sari as our research manager for delivering the remarks. Please.
Distinguished speakers, professor, and also the participants in person here in the room, as well as online participants. I make apologize for giving the closing remark, but it is not for the conclude this discussion. So you could continue to the discussion and question and answers session. So this seminar on development laws and dispute resolution in Asia in search of an alternative for sustainable developments. Today's discussion have reaffirmed the vital role of law in advancing sustainability through justice and inclusion. So for all of the matters in the law and dispute in the regulation, the term of the justice and inclusion is a must and is a key factors for sustainable development. And the seminar has emphasized the importance of legal and dispute resolution frameworks in addressing environmental challenges, the protection of the labor rights, and the promotion of gender equality, agrarian resolution disputes, and also hak ulayat and land protection. So grounded in academic excellence, research-based insights, and innovation. I hope these efforts are strengthened through the collaboration between the Graduate School of Sustainable Development, University of Indonesia, with the Kobe University Center for Social Systems Innovation, reflected a shared commitment to sustainable development in Asia. So it is hoped that this collaboration will continue to foster scholarly exchange, joint research, and innovative legal solution. For you to know that we also have a course in environmental science department that related to the law and policy, public policy. So this is very important that we are concluded and making this aspect of the legal law and public policy into our curriculum. So thank you for your participation. And this seminar, I'm not making a conclusion for this. Let's continue with the constructive discussion further. And I hope that this is making a good discussion and constructive discussion into the innovation solution. Thank you for all participants. Assalamualaikum warahmatullahi wabarakatuh.
So thank you very much, Bu Sari, for the remarks. So now I will invite all the presenters, all the speakers come in front on the stage. So there are some questions already from the online participants. And due to the time constraint, I think I will invite one question, if I may, in this room, if you want to ask to our speakers. So please, I invite for all the speakers, so we can also have a good picture if they want to portray us. Please. I think maybe we can have a one picture with Ibu Sari and also, sorry, Professor, if you can come with us to take a picture before we have a discussion. Come forward. Berdiri dulu. Berdiri. I think all of us can stand here. Bu. Take a picture, yes. Okay, I think done. Thank you very much, Ibu Sari. Thank you, Professor. So, since we have 4 questions from the online participants, but I will invite one question from me. Oh, okay, I limit 2. Is it okay? Okay, 2 questions. short and sharp. Please, from the back of the room. Please name and.
All right, good afternoon, maybe. Yeah, good afternoon. My name is Joko Susilo. I'm a student of Master of Law, University of Indonesia, major in human rights and good governance. Straight to the questions, I think I'm going to ask the question to Mrs. Suciwati regarding the gender equality in the palm oil industry. I would like to ask a question. You mentioned about the human rights due diligence, and that kind of interesting. That's kind of interesting because, as we know, that the oil palm industry is not really that kind of helpful for the women and also the child labor especially. And my questions is, how do you make the indicators? How do you make the benchmarks for the human rights diligence in terms of the actions needed to the progress of this, the fixations of this? I think it's a drawback of the regulation instead. Thank you. Joko Susilo, yeah.
Thank you
from
very
University
much.
of Indonesia. Thank you.
Yeah, thank you. Okay, one question more. Another question. Okay.
Thank you. This one is for Prof. Mizuno. Hi, Prof. My name is Anditya Sudirgo. I'm from the private sectors, mining. So my question is about the customary forest. I mean, you've discussed with your colleagues also. My question is, have you considered about the implication of the use of the customary forest in terms of the separatism? Because going back to the fundamentals, Indonesia, the constitution law under 1945, all the resources are under the management of the nation, of the state. The constitution also acknowledge the customary law community. So those two are acknowledged within the constitution. But again, it is under the management of the state or the nation to make sure that the interest is under the national interest, not for certain groups. So how do you balance between these two and make sure that the horizontal conflict does not happen within amongst the community group? Thank you.
Thank you very much. Sorry.
Anditya.
Pak Anditya.
Yeah.
Okay. So Pak Joko and Pak Anditya. Thank you. I will back to the page. So I think we can respond for the two questions first. Bu Mia and Prof. Mizuno. For the first question, Bu Mia, please, about the indicators. So.
I think this is okay. So thank you, Bung Joko Susilo, for the question. It's actually the most important thing is the recognition. I think about the human rights that we need to, like, the companies should also follow the obligation of the state of the recognition and the protection of the human rights. And for this case, is actually the women's rights as a workers. For example, the rights for them to have a day off of during the menstruation period, and also that they need to have also the facility for them to protect their reproduction health. That's so the facility, and as also the rights to have actually not only the day off, but also to have the time, especially during that period, not to have such a burden for their their work. And other things is also the implementation of the in my opinion, the monitoring of the prevention of the forced labor. And forced labor happen in the oil palm plantation. This is not only for women, but could also be happening in the family. So this is not only about the indicator, but the system, the monitoring system to really prevent that to happen. And how to prevent that? Actually, so law enforcement, and also to avoid the existence of such a brokerage in the recruitment system, and also the grievance mechanism. So the workers should freely give the opportunity to report, and like to feel free to report about the situation without feeling it's like safety for their safety. So that the company should provide that kind of mechanism and system of monitoring, and also the safe kind of safety environment for the workers to really report. Otherwise, the management of the company, they don't know because what's going on in the field. This is what happened actually during my research. Certain companies, the manager, what they know is like, we do not have that practices, but in the field it's like that's what happening. So the mechanism, and also the monitoring, and also like a kind of safety environment for the workers to really report. Thank you.
Thank you, Ibu Mia. And then for the next question, how to balance, Prof. Mizuno, regards to the emergence, for example, the separatism and so on. How to balance?
Of course, there is the hak menguasai dari negara, right of the state to control exists. That is stipulated in the constitution, and also many, for example, basic agrarian law. On the other hand, the customary community also mentioned or protected in many regulations. For example, the basic agrarian law also says that they clearly recognize the hak rakyat, or the hak of the customary community, of course, as long as they exist. And also basic forestry law, 1967, recognize the hak rakyat, or hak for the people of customary community. And also, so many regulations. For example, the present regulation of 2023 regarding to the national strategy for business and human rights, that also clearly mentioned the protection or the respect the right of customary community and the hak rakyat. So hak menguasai dari negara, right of the state to control, adjust everything, right of the local people, of course the right of the company to operation. So those should be adjusted for maximize the interest of Indonesian people. That is stipulation in the constitution, I think.
Okay. Thank you, Prof. Maybe for question, I think we have 3 questions from the online. So 3 questions I will divide to Pak Andreas and also the 2 professors from the Kobe. So first is to the Professor Kaneko, I think, about how can customary and community-based dispute resolution mechanisms function as sustainable alternative to formal litigation without perpetuating power imbalance and social exclusion. And then for the next question, for the Professor Kagawa, I think about what indicators should be used to evaluate whether dispute resolution mechanisms genuinely contribute to sustainable development. And the last question, actually, it is the first question from the online about the environmental dispute Pak Andreas, often like have no solution because stakeholders sit at the different perspectives, especially at mining areas, often create conflict between economic, environmental, and community. From your perspective, what are the most effective approach to finding solutions in mining areas, especially when stakeholders have very different priorities? So I think similar with the Mr. Adita question, but to answer this, I think Prof. Kaneko, you would like to answer about the first question about how can customer and community best dispute.
Hi. Yes. Thank you very much for the question. Yes, I know that the importance of community-based dispute resolution system, particularly for the disputes in the community. But if the dispute comes to the type of disputes between the community's right and the state's right to control, then perhaps the community-based dispute resolution system itself cannot solve this. So perhaps we need some formal linkage between certain community-based dispute resolution and the formal dispute resolution system. And you may think that the formal system may result in social exclusion, but I emphasize the need of formal law reform to prevent it. That we can improve the formal law so that the formal law is applied for the sake of communities' right to be realized. And that is possible under the constitutional views, as Mizuno Sensei emphasized, in balancing between the people's rights and the state control rights. You have the system of compensation in case of taking. It's okay that the state control the mining, but if in this process a state caused a lot of pain, a lot of damage to the local customer lives, then it has to be compensated. This is the must of the constitutional norm in all civilized countries, including Indonesia. So I think it's a role of lawyers to emphasize these legal rights and support the movement, and then through the linkage between community to the formal system.
Thank you very much. I think the two things, the linkage and I think the compensation, I think we should consider about that. That is the answer from Prof. Kaneko. And for the next question, I think still the same person, Chesa Helsin Kiswian, asked about what indicators should be used to evaluate whether dispute resolution mechanisms genuinely contribute to sustainable development. Please, Prof. Kagawa.
Thank you for your questions. I think that there are many indicators to evaluate whether dispute resolution mechanism contribute to sustainable development. One important point is how to maintain how to compile the content of the awards or the resolution. It is important to keep the content, to execute the content of the resolution or award. And also, it is important to occur the new problems, not to occur the new problems from the award or resolution. So, and I think the industrial relations continue the relationship between employees, and so continuing relationship is very important. And so today social dialogue is very important to communicate between the employers and employees and trade unions. So dialogue is most important. So usually exchange of the opinions must continue to resolve the problems.
Yes.
Yeah, thank you.
Okay, thank you, Prof. So it's about how to maintain the relationship and also about the dialogues itself, the indicators to find out the resolution mechanism. So next question is about the environmental dispute from the Yusnani, yeah, and I delivered to Dr. Andreas. From your perspective, what are the most effective approach to finding solutions in, for example, mining areas, especially when stakeholders have any different priorities?
Okay, thank you, Bu Yusnani, my friends from School of Environmental Science. This is the situation in mining case, especially how to role of stakeholders and how to effective, especially to final dispute resolution, especially of economic, social, and environment. The use of dispute resolution, we need all effort to finish the case. One, use of the alternative dispute resolution with the negotiation and other else. If the fail of alternative dispute resolution, you must go to the courts. And then, how priority about this? This is not easy. We must to see the problem, yeah. The case have each the problem of economic, problem of social, or problem of environment. You must identify this problem. And after that, how to get the goal to the finish. So it is need to some tahapan, what step, yeah, some step, yeah, to situation, condition is very different situation, yeah, and then you can get how priority to finish the case. Yeah. I think this is the saran, ya, recommendation, suggest. Yeah. Okay.
Okay. Thank you, Dr. Andreas. I think identification and prioritization, I think that is steps to answer for the question. And actually there's one comment from the online to Ibu Mia from the GAPKI. GAPKI member, Bapak Sumaryono Saragi. He is surprised that you are talking about the labor on the palm oil, and he offer and welcome further collaboration to address various relevant aspects relating to labor in palm oil. To Ibu Mia, he also gives the context, and we will send to you later. Okay, I think thank you for the informative and engaging discussion. I think I'm not here to summarize, as each speaker, I think, already presented their conclusion. I hope this seminar provides valuable insight into dispute resolutions and its strategies in Asia, particularly in Indonesia. For everyone here, join directly and those joining online. So thank you very much. I'm here to closing this discussion, and I give back to the Master of Ceremony. Thank you.
Thank you, ladies and gentlemen. Following the agenda, we will now proceed to group photo session. May kindly the participant come forward to take a photo with the speakers.
All the participants.
Yes.
Kayaknya ini aja deh. Kasih mamnya.
Okay, we can. Okay, thank you. Please be seated. And then, following the group photo, we would like to give some appreciation to the speakers. To Professor. For all the speakers, please stand up. We invite Professor Mizuno to give some appreciation.
Facilitated by us. Because the local government request support from us. Okay. Ya.
Kasih ini dulu Prof. Jalan aja dulu ke Prof. Nggak, karena
Because not the place almost not public, it's not a public place. The only one that can book that is the chapter. For Balai people.
Dan siapa aja?
I will give you a So, Oh, you don't need ticket. So you just once you arrive in Makassar, the airport, you go into the Pelita counter. I'll take the details of just bring your ID because I already registered your name. So you can just bring your ID.
To all the speakers, we invite to come forward and get the appreciation from Professor Mizuno. Suruh take foto bareng. Yang mereka Okay, ladies and gentlemen, we have come to the end of our agenda. On behalf of the organizing committee, I would like to extend our sincere gratitude to all distinguished guest speakers and participants for your valuable time and contribution. We hope today's session has been insightful and meaningful. Thank you, and we look forward to seeing you again to the future events. Have a wonderful day.
So,